Welcome to Grow For It. It's a podcast for small business owners, managers, and professionals. The goal is to give me a chance to work with the space between your ears, on your mindset, to help you focus on the things that really matter to your success. I want to enable you to concentrate on pursuing your vision, setting meaningful goals, and engaging in the day-to-day activities that will have the biggest impact. Thanks for joining me. Hey, welcome back for this episode. Today I have a guest in the studio. Parker Wornall is a local attorney, and we're going to talk about reopening during the COVID-19 crisis, small business guidelines and considerations, things like that to kind of help you guys as we kind of unlock this logjam and try to get back. But before I get down too far, I want to go ahead and make sure that I introduce Parker to you guys. And hey, Parker, welcome, buddy.
Hey, Jim. Thanks for having me.
Absolutely. This is about the second or third time you've been on this podcast, and you were actually on a radio show that I did back in 2019. So you're kind of getting to be an old pro with this.
I've got a face for radio, so this is a good fit.
Hey, I look really tall on radio, so I think it's working for both of us. Hey, do me a favor. You're with the Commonwealth Counsel Group, PLLC. Tell us a little bit about your firm.
That is correct. So I'm with Commonwealth Counsel Group, PLLC, like you just said. We are a 5-person firm that focuses on small to medium-sized business representation. We handle everything from the startup to the shutdown and everything in between. We focus a lot on complex civil litigations, ranging from the construction industry to employment issues, restrictive covenants. We cover a pretty broad spectrum of business-related issues. We like to think of ourselves as kind of a one-stop shop for your small to medium-sized business.
You have a special niche that you've kind of developed over the last few years dealing with licensure defense. Do you want to tell us a little bit about that as well?
Yeah. So early in my career, I was subjected to several clients, both at the Board of Nursing, the Board of Medical Licensure, and that has since kind of bled out into other licensure boards and other things regulated by the state administrative level, those state agencies. And it's really one of the most fulfilling areas of my practice because I live and operate on a license. These individuals live and operate on a license, and it's really quite humbling to be able to help them protect that license when it comes under fire. So yeah, I really enjoy that area of work.
Great. And friends, I'm going to put Parker's contact information as far as the office phone number, the link to his website, which is ccgattorneys.com, all that information in the show notes. So if you're looking at the show notes either on iTunes or on the website or wherever you find this, you should be able to find his information. So I want to make it very helpful in case you hear something today that makes you want to raise your hand and go, oh, you know what, I need to figure that out. Parker and his team over there would be very happy to help you. So, Parker, let's jump into this. I mean, everybody's been locked down, and to some extent that's still in place, but things are slowly starting to reopen. And I think what I wanted to do with this episode was try to get out in front of that and talk to some small business owners to say, hey, look, these are some of the things you need to be aware of and some of the issues you may be confronted with as we kind of get into that process. I know you dealt with a number of the PPP loans that were coming through. You had clients that had that and were wondering how they have to deal with that and distribute those funds. Why don't we start there, and then we'll get more into some of the regulations and just general guidelines.
Sure. So when all of this COVID-19 pandemic started, we kind of reasonably foresaw this playing out in two waves, and it's turning out to do that. So the first was, do we have to shut down? How do we shut down? How do we let go of employees? Is it a furlough? Do they go on unemployment? Fielding all those questions. And then the PPP came into effect, and it was at first, do we fit? Can our company apply for this? What are the loans going to look like? And now we're moving into the second wave, which is, hey, we're reopening. How do we bring employees back in? And we've got this PPP money, the Paycheck Protection Program. How do we spend it to essentially convert it into a grant instead of it converting into a loan for the misuse of those funds?
So how do we make sure those funds are forgiven if that still stays intact, basically?
Exactly.
So, how do we get the free money, and then how do we keep the free money?
Correct.
Basically.
And unfortunately, what people are finding out is that the devil is in the details. So,
which we didn't have at the outset.
Right. Yeah. That's Uncle Sam's always going to get his money if he can. So there is and ever-changing landscape with how these funds need to be spent in order to be forgiven. So one of the first steps I tell every client that I've kind of walked through this process with is to get a separate account. If you have those funds, put it into a separate account. That is going to make accounting and the paper trail that much cleaner for whenever the government does they start retroactively fact checking all of this, several months down the road from now.
Right. It's just you can set that up from the outset so that, again, you avoid any question of impropriety so that, again, those funds remain forgivable. And it's easy compliance. It is a little bit of a hassle to set up a separate account, but it runs fairly quickly. But now that rules have come out and the IRS and the Treasury Department have issued the guidelines, we're finding some of those bars a little bit higher than we thought, and some of those loopholes suddenly are appearing where we didn't realize. So good news is I saw today there's an attorney I follow out of Ohio, Buck Mallory, who reported that some of the lawmakers are going back to pass another bill, or at least attach something that's going to make some of those regulations, some of those provisions maybe a little bit easier for the small business owner. So fingers crossed, hopefully that happens. I think for a lot of us, I don't have employees per se. I contract some work out, but for the most part, this has been a little bit easier for me than it may be for an organization that's got, a team that works with them and for them. And so as you look at this, this conversation is probably also going to veer off into protecting patrons and clients and customers, however you classify them, coming in. So why don't we, first of all, kind of talk about really planning and implementing as we go for this reopening. And what are some of the things that really, as a small business owner, we need to be aware of?
Sure. So, when you think small business owners, and I'm glad that people still think this, but you typically attribute that to a brick and mortar, a storefront. You think, there's a local business in town. I'm going to go there and I'm going to purchase their services or their goods. And in Louisville, especially, that still very much is the case. I think we're going to see somewhat of a trend towards remote work, just as a natural consequence of all this. But people want to open back up, and the general public wants people to open back up. So how do you do that? And particularly, one of the buzzwords that I'm hearing a lot is CDC. I've never heard the CDC mentioned so much than I have in the last 2 months. So, what are those guidelines? How do we remain compliant? What happens if we don't remain compliant? So, I call it common sense, even though it's so rare. But your common sense approach is just to, start with the basics of a plan. What kind of business do we operate? What kind of foot traffic do we have? What are people touching? If you don't have a cleaning service, this might be a good time to get a cleaning service. If you have a cleaning service that only comes irregularly, this might be a good time to have them start coming every few days, or weekly. If you're a licensed individual, like I'm general counsel and do some compliance work for several different licensed entities, ranging from psychiatrists to dentists to nurse practitioners. So all of these things have their own complexities. And you think, okay, what are clients going to be exposing to us? What are we exposing clients to? What do we need to do to keep these surfaces cleaned? What do we need to set our capacity at? Do we need to be more intentional about limiting our appointments and getting out in front of that? And I'm seeing a lot of promising and really kind of forward-thinking appointment setting with industries that even I wouldn't have expected, say like furniture stores. You want to come in, buy a couch? Hey, we're going to have you come in and do an appointment. So these are all good initial first steps, is just to spend a few hours one day sitting down with a notebook and writing out some thoughts. The second part of that is converting it into a policy and publishing that absolutely everywhere you can, because the more you publish, the more you protect yourself. So make sure your employees see your policies, and make sure that your patrons see your policies as well.
And these are things you might put out either in a video to your team. You might put that out in an email of some sort. You could do a podcast like this internally. I saw some articles yesterday on internal podcasts. just to let your team know that you are taking necessary measures, that you do have their best interests at heart, and that you've communicated that effectively. I think those steps are important, and I think a lot of people are going to look at, did you take reasonable steps? And I think that hopefully comes into play, not always with the law, but I mean, you've got to show that you demonstrated, you made an effort. Some of that may be, hey, we've put hand sanitizer all throughout the building. We've made that available to our employees. Masks and things like that. I would think that would be a provision that you might want to look for. You might want to start sourcing some of those ahead of time and maybe coming up with a policy. Are you hearing those kind of questions and your clients looking for guidance in those areas?
Yeah. So
those seem like the basic ones, but
yeah, it absolutely is. And that is, when we see compliance pushes from the various entities that can impose the restrictions of the CD or the guidelines of the CDC, or the other side of that is some of these new acts regarding employee rights that have come out. There are some very subjective standards. Some of the guidelines are rigorous. They're in black and white. It's easy to read, easy to enforce. The PPP, to the extent that they make those easy to find and read, it's did you spend it or did you not? But some of these rely on the infamous reasonable man standard that courts have, played with for centuries now in many different areas of law. So a lot of it is going to come down to that. What is reasonable? What can we reasonably expect? What do you have access to? What can you actually impose? And a lot of that comes down to the size and nature of your industry. So it's really going to look different for every client pretty much that comes in through the door. It's going to look a lot different for a dentist than it is going to be, say, yourself, who does marketing services and consulting. So
yeah, my engagements are a little bit different. In fact, if you're wondering now, we have social distancing right here in the studio, just making sure that their common sense, reasonable measures are available. Parker, I might guide your eyes over here to the hand sanitizer to your left. Thank you very much. But things like that, where again, making it open and obvious. I guess the subjective nature of this, which is really why attorneys get involved, is what's reasonable to one person may not be reasonable to another, and so that's where that gray area comes in. And that's probably going to be the nature of a lot of your work going forward. Is walking through. Did you have a plan in place? Were you consistently implementing that plan and enforcing that plan with your team, with your staff, with your clients? And then how did you communicate that? So I think some of those initial steps right there are pretty important. From a protection standpoint, what are we talking there? I mean, are there other things that we need to be thinking of in terms of steps that a small business might need to take? Obviously, financially, making sure you're tracking how you're dispersing your PPP funds. That's one area. What are you doing to protect, from a sanitation? And I love that tip about maybe you need to step up your cleaning services. I think if you're employing a cleaning service, at least that shows you're taking action, in the right direction. I think that's better than laying off your cleaning staff, obviously. That may open you up down the road. But are there other areas in what we might call the topic of protection that you might want to discuss?
And a lot of that is, me thinking towards litigation. Everything that I'm doing whenever I get into helping a client is how do we avoid litigation, or if there is litigation that comes up, how do we ensure that we're going to be able to make a straight-faced presentation of what we've done, and how are we going to be able to launch the most successful and comprehensive defense. So a lot of that, like I said earlier, publish. The DOL, the Department of Labor, has certain requirements that you always have various notices posted at your place of employment. If you're scratching your head wondering what I'm talking about, you need to call me for other reasons.
But they could be on the bulletin board in the lunchroom and things like that. You see
Correct.
Workers' comp notifications. You see all sorts of different communiques that come out from, let's say, management that the team needs to know about, and you're required to have those posted in the various areas. That's kind of the nature of what you're talking about.
Yeah, absolutely. And a newer example of that is with the Families First Coronavirus Response Act, which is the Department of Labor has condensed down to a nice little one-sheet notice that you're required to post in your place of work. And I would urge you to call me if you ever have questions about that as well, because that one-sheeter should be about a 14-page document, given the complexities of that new act. Again, the devil's in the details. But yeah, put up your policies and procedures for CDC guideline requirements. Put it up right beside that, because one of the first things that I look at in any litigation, or if I'm on the other side and I'm defending the company, is one of the first questions in discovery, one of the first document requests is going to be, give us your policies and procedures, whether it's pertaining to payroll procedures, looking for employment agreements, how do you handle internal investigations? Everybody wants to see, and it helps you launch the most successful defense if you have a written policy and you show that you have emailed it, you've posted it, that you've developed it over time. Keep track of all your changes too. If you've posted one this month and then new requirements come out next month, keep copies of both of those. It is going to do you a world of favor if, the unfortunate in the unfortunate circumstances that litigation arises, you're going to be ahead of the curve.
Right. And I think keeping version controls, document control is important, so that if this is new, somewhere within the four corners of the document, you say, okay, this is version 2 and maybe a date. I've worked with a number of companies where, I've suggested, guys, you really need to have good document control measures here, so that not only do you have it posted, but if there's a change, you have a retained copy in the file, maybe in the manual or somewhere in an appendix. But at the same time, you note that somewhere so that okay, everybody's looking at the same document, because sometimes one of those might get overlooked. So you can very quickly kind of walk through the building and go, yep, this is the current version, this is the current version, this is the current version. If down in the bottom right-hand corner, maybe you put that down, version 1, April, 2020. Little things like that. But I, again, retain those documents. And I think one of the advantages here is, let's say this thing, wears out for a while, but something similar happens down the road. You'll already have some of the road work already laid, because you can go back to, okay, what did we do last time? And I think for a small business, this may be the first time we've really hit this. So, why throw away that knowledge? Just because, okay, the crisis is over, let's throw away everything. No, retain that, because now you kind of have a roadmap for how to address it more efficiently next time.
Yeah, absolutely. And, kind of building on that, this touches on it a little bit. Going down that road where you're developing things, there's always going to be internal communications. That's another value add of having an attorney that you bounce ideas off of and attach them on internal correspondences, is because that becomes protected under attorney-client privilege. So if you are, wondering how to handle a leave request that might be contemplated by this new Families First Coronavirus Response Act, and you and your business partner are, emailing back and forth jokes and, boneheaded ideas about how to deal with this,
right.
That doesn't read well in court.
Right.
If you're saying, oh, well, employee A is over 60, let's just cut her loose because she's old anyway. Don't put that in an email. And
never.
These are compliance issues, should always be bounced off an attorney, because a plaintiff's attorney will inevitably cherry pick those correspondences where you're trying to work out a complex issue. Somebody has an idea that is not the best, and they'll bring that to the
forefront. It's a point of levity. They're just trying to, break up the stress a little bit. So they make an offhand comment that suddenly is codified. That can be taken out of context.
Exactly. And that will be Exhibit A. So that is, and just to kind of parlay a little bit into general counsel services, that's the relationship I now have with most of my clients. When you initially engage me, there is going to be, really the first couple months of getting to know your industry, to know your business, to know who all your employees are, to look at your contracts, both internally and externally. That's really the biggest bulk of the work. Once we get over that initial hump, most of my clients, I'm at the point where work becomes proactive, and you're spending, you're spending pennies on the dollar per month to get out in front of issues, instead of, bringing me a big pile of problems and spending a lot of money for me to try to retroactively fix it. So
after the fact.
Yeah. So, an ounce of prevention is worth a pound of repair. And that's ultimately what I want to try to get to with clients. I get the most value and satisfaction out of working through these problems and making sure that they are adequately addressed the first time, as opposed to trying to re-piece together something that blew up and is now going to litigation. So be forward thinking, call an attorney, get them on your correspondences and bounce your ideas off them.
Well, and I think that the value to this is that you're seeing a number of different business entities, different industries, different types of organizations grapple with this. So you may have ideas from other conversations and other perspectives that you can add into that decision-making process for your client. And that's, again, value, because sometimes we get the blinders on. Well, this is my world. This is all I'm thinking about. And I fail to consider other things. So I've got a blind spot. I mean, it happens, and I think if you're going to, you'd said at the outset, maybe sit down with a notebook and maybe put down some notes and start formulating policies and procedures. I think it's a great idea. But I would also say, who are some of the other people in the organization who might have input? Because, again, we all have these blind spots. But before it goes public, have somebody like Parker come by and review this and point out, well, have you considered this? Because I think, again, if you can avoid that problem before it occurs, you just won. I mean, you just won the game right there. Even if you're correct and it takes you thousands of dollars to prove that you're correct, did you really win anything? And I think that's, again, some of the value that you brought into my organization. When I have questions and when I have legal issues that come up that I really want, hey, am I reading this right? And I can go to you and you clarify this stuff pretty easily. And you go, okay, I'm on solid ground here. Okay, this is proper. But it just, again, it kind of keeps me able to sleep at night. And in something like this, when you've got not only employees, but also clients potentially looking to figure out, hey, did you do something wrong? It'd be better to make sure you're on solid ground. So, I really appreciate what you're doing. In terms of non-compliance, when we kind of get into this, so is there a non-compliance police out there? I mean, how is this going to be turned in? I mean, I think probably somebody calling an EEOC office and making a complaint, or where does that happen, or how does that usually happen?
Yeah, so that's a good question. You're never going to see a CDC police. Nobody's going to show up in a vest that says CDC on the front and knock down your door and say you're going to CDC jail. This is going to come from a lot of different, possibly unexpected angles. One that I have, particular insight into is through, say, state licensing boards. And you might think, well, this is a federal act and there's a state licensing board. How do those two interact? That's a head scratcher for me as well. But I can tell you that most licensing boards, if you are a licensed professional, they will have, their enabling statute and their regulations that give them authority to reprimand, suspend, revoke, do whatever they need to your license in order to have full governance over it. Usually within those, there is kind of a catch-all, and to some extent it will say, we have the ability to act on any action by the license holder that is in violation of public policy. And one pragmatic example of how this is played out is that you have HIPAA, which is the Patient Rights Act that you hear a lot about. Well, it's a federal act.
That's a lot of times medical records and conditions that you hear in a hospital situation.
Yeah. I used to get calls all the time from people saying, well, my HIPAA rights have been violated. Well, first off, one of the interesting things about HIPAA is there is no private right of action. I can't sue you, Jim, if you go around and you post my hospital information. HIPAA is its own enforcement branch. One of the interesting things is that the Board of Nursing in Kentucky can enforce that federal statute. And what they do is they say, well, you had a nurse that made unauthorized access to a patient's records, and this is against public policy. So they catch it all in their catch-all provision, and in their roundabout way, they can actually enforce HIPAA regulations. that's a long way to get to this, but that can happen with the CDC regulations. And yeah, I've been looking at it the last few days. There actually is some older precedents for not related to COVID-19 compliance, but with communicable diseases from other states. State licensing boards do have a history of enforcing CDC guidelines on individual licenses. So you may not be thinking that, say your board can come out and make you wear face masks. Well, they might be able to, and I would expect they're at least going to try. This could possibly also give rise to OSHA actions, and OSHA is, again, its own entity. They enforce their own rules, but they can catch provisions from, say, the CDC and swallow it up into their own enforcement. So if, say, you are a construction firm, if you're a general contractor and you're not following CDC guidelines and you have OSHA requirements, I can reasonably foresee OSHA coming in and saying, well, you've been non-compliant. This violates one of our catch-all clause. We're gonna take action against you. And the third, and what probably most people are going to think about, is tort liability. And tort is basically, the biggest tort claim that most people think of is negligence. So, if you are being non-compliant and someone sustains an injury from your non-compliance, it could give rise to a tort claim where a patron, client, or otherwise can actually bring suit against you and say they were negligent in this way. And that way would be, I walked in and they had somebody walking around with a bottle sprayer spraying COVID-19 all over surfaces, and here I sit sick. So those are just a few ways. I think we're going to find out a lot of unique ways that these guidelines can develop teeth. So, if you're thinking, well, the CDC is not going to come after me individually, that's true, but other people will, and other people
agents and other governing bodies or oversight, with regulatory power, obviously can come in and stir up a storm very quickly.
Yeah, absolutely. And if you look at the amount of calls that have come in through the state, our state and other states, through the hotlines for noncompliance, people are very willing to impose these guidelines, both through the CDC and through our governmental executive orders. So people are not going to be shy about holding people accountable for following these guidelines.
Well, especially I think right now with the economy, takes a downturn like it has and it continues, people are going to start looking at their own self-interests. And if that means, hey, there could be a paycheck out there and I can go hire a plaintiff's attorney on a contingency fee, which means I don't really have to pay them, but there might be a payday for me down the road. Unfortunately, you might see some of these lawsuits really bubble up, and then they kind of gather steam, and other people think, hey, there might be a money trail there. So, again, that comes back to being very thoughtful about your policies, about your protective measures, publishing those very, very visibly, and maintaining some level of consistency. And I think, maybe if you've got a team that has subgroups or sub-teams, making sure your supervisors are having those direct communications and explaining that and giving time for Q&A so that people feel more comfortable. Again, this all comes back to your comment about being proactive in this. And I think that's going to be something that's just going to be important right now, because we don't know where this is going to go. We don't know how long this is going to last. It could dry up over the summer, but that doesn't mean the lawsuits are going to dry up over the summer. And those are the things that come back and bite you. And I think, as you look at the measures and the steps you're taking, understanding that you've got to be hyper vigilant right now. And some of that just comes back to basic communication. I think that's been kind of a theme of today, has been, publish, retain the records, make sure people understand it. But are there other sources or other ways I might be able to go out as a small business owner and find other steps I may not even be thinking about? It comes back to that blind spot comment that I was making earlier.
Yeah, and a lot of the issue with this is that, I've compiled memorandums for several clients that are changing almost weekly.
Yeah.
I'll update it and I'll say, this is what it was last week and this is not what it is this week. So some of the best sources I've found are original sources. So try to cut out as few of the middlemen, or try to cut out as many of the middlemen as you can. So The executive orders from Governor Beshear are posted directly to, there's a link every day that brings out the new orders. Go directly to those orders. If you are looking for PPP protection.
You mean as opposed to somebody's interpretation, hey, this is what the new order said, go back to the original.
Correct.
Okay.
Yeah, absolutely. Because, everybody's going to have their own twist. And really in the legal world, all it takes is changing one word, and that can change the entire interpretation. I mean, if you look at, several centuries worth of contract law, the difference between may and shall has caused wars, essentially.
Exactly.
So, yeah, go directly to the source. If you're wondering about the PPP, go directly to the IRS, see what they're requiring, see what kind of bulletins they're putting out. I'll tell you another good one that has compiled lots of direct links and original sources is our state's Cabinet for Health and Family Services, CHFS, which spans a lot broader than people would think. There are so many sub-agencies within the cabinet, but their CHFS website has a lot of direct links to the CDC. It's really been a good mechanism or a good vehicle for me to kind of get straight to the horse's mouth instead of just reading interpretations. So I would say, find 6 or 7 good sources and check them, if not daily, then every few days, because things are continuing to change rapidly.
And I think as a small business owner, that's one of the points of frustration right now is I'm drinking from a fire hose. I've not only got these constantly changing rules, policies, interpretations, but I'm also trying to run my business and make sure I keep that afloat. And I've got, all these other concerns, and it just, I think for a lot of us, that is the biggest point of contention is there's not a lot of clarity here right now, and the ground beneath our feet seems to be changing and shifting, and that makes it very complicated for a lot of us. The when you look at all these government mandates and stuff that come out, I mean, obviously somebody's going to miss something from a defense standpoint, and obviously you defend businesses and business owners. How do you begin to pull that apart and really defeat a claim or an accusation that may be made? I mean, obviously you're going to look at policies, procedures, things like that. Can you kind of walk us through other things that may come into play in a situation like this? Because I mean, again, these things are going to happen.
Sure. I'll tell you a few thoughts, and they're somewhat interconnected and some aren't. But one you hit on a little earlier, you mentioned supervisors and managers. The bigger your company gets and the more diverse your employment structure is, think about who can act to bind your company. And, if you have supervisors or managers, most often anything that they do can be binding upon your company. If you have a very hierarchical structure that's kind of segmented at the top and you think, okay, well, here I am, president or CEO, I make the binding decisions. Well, as the courts see it, if you've got a manager that you're not keeping good control of, that manager may take an adverse action that can bring your whole company under fire.
This could be a comment. This could be a way they enforce something. This could be something they did.
Correct.
Yeah. They're an agent of the company.
Yeah, absolutely. And since you mentioned agents, one of the things I always have to sift through with clients, regardless of if there's a ongoing pandemic or not, is how do we treat the employment versus independent contractor relationship? And a lot of that is now coming to light in a different way with, okay, I had employees and I'm now having to bring them back as employees, or I had employees that I'm now having to bring back as an independent contractor because their scope of work has changed significantly.
So now they're a 1099 employee.
They can be a 1099. How do you deal with letting go and re-onboarding somebody who is always an independent contractor? How can they bind your company? So in a lot of different ways, both from the Department of Labor's perspective, and now we're going to see a lot of other entities, there are some significant considerations when you're looking at how your employment relationships are structured. You would be surprised the amount of people that don't have any type of contract with any employees. And in some industries, you can get away with it. In most industries, I'm going to tell you, you just can't. You need
just
to
open yourself up for problems.
Exactly. You need to get it down on writing that at least says you're an independent contractor. This is your scope of duties. you can go work elsewhere. I mean, the litany of elements that go into that consideration is pretty large.
Well, the nice thing is once you have that document created or that contract, it is to some extent a template that you use, in various similar situations. So it's not like you have to constantly recreate this and pay for an attorney to redraft it. Once you have it more or less. If the nature or the nuance, necessitates a different document, well, okay, so be it. But for the most part, once you have this, it's like a policy. Once you have it in place, it should be good to go as long as you're consistent.
Yeah. So really with my general counsel clients, getting those initial contracts tailored, it's not as expensive as you might think. I've done so much contractual work that, it's pretty easy for me to get to the information that I need and get you the results you want for a pretty reasonable price. And two, you're right. When you're bringing on somebody new, you can typically get it down to sending me a list of elements, say, here's what we need. Can you check this, make sure we're good to go? I say, sure. Or, we make minor tweaks and it costs you next to nothing. Along the line of contracts, another thing that I've seen, and this initially stemmed from the insurance world, is I have heard of a lot of policyholders that are having issues filing claims for various reasons under their insurance policy because things such as a pandemic do not preclude certain actions. It's not built into contracts, and people are having a lot of issues getting claims through this, that, and the other. So one of the things I've been doing for a lot of my clients that I know have contracts with third parties is going back in and looking at that force majeure clause, which basically means act of God. And to the extent that it didn't previously contemplate a worldwide pandemic, I'm starting to build language. I'm starting to build language into those contracts that say, in the instance that there's a health pandemic and A, B, and C go wrong. So even just tweaking those clauses, for clients that have a general counsel relationship with me, that's been a value add, and it's been an easy fix. You fix one, it only takes a couple minutes to do the rest.
In having lived through this as we are right now, I mean, obviously it could happen again. I mean, we've been through Ebola, we've been through SARS, we've been through all these other areas. It would be nice to have that document updated. And if you haven't done that, this is a good time to understand, these kind of things are going to continue to happen. So go ahead and get your language updated in the contracts. I want to come back to one thing dealing with the employees and the changes. A big area of law, at least over the last 10 years that I've paid attention to it, is improper classifications. And I think right now a lot of people are probably scratching their heads going, do I have exposure here? And what I'm specifically talking about is someone who you may classify as an independent contractor, when in all reality, they're an employee. And there's a substantial difference there for a lot of reasons. But I think as people kind of come back to work, I mean, that may be one of the considerations that you, especially if you don't have an HR department, may be thinking through. Do you want to kind of touch base on that just briefly and kind of go through what some of that exposure and what some of the problems might be?
Yeah. So that has implications with both the Department of Labor. The biggest financial hit for most people that have misclassified is going to be through the IRS, though. So if you have, say, a dozen or so independent contractors that have been improperly classified as such, and you have been offloading the tax burden onto them for the last handful of years.
Because again, if they're 1099s, I don't have to pay payroll tax. It really goes back to them. Correct?
Exactly.
Okay.
Yeah. So, if in the short term you're thinking, okay, I'm going to get these people 1099'd, I'm going to treat them as independent contractors, but you cross that line into employment. Some of the biggest considerations are obligations that they owe to your company and only to your company. I work with some real estate brokerages, and of course, most, if not all, real estate agents in Kentucky are 1099s, independent contractors. So it's, can you require them to come to monthly meetings? Can you require them to have office hours? Can you require this, that, and the other? And a lot of times the answer is going to be no. If they're a 1099, they have to be an independent contractor. And there are a lot of gray areas in that, but there are also some very
Red line areas.
Very red line areas.
Yeah. Because it really does come back to the amount of control the overall company exerts on that individual, or that group of individuals, right?
Correct. That's probably the best buzzword to categorize the entire approach that either the DOL or the IRS is going to look at as control. And if you've misclassified and you get an IRS notice that says these people should have been W-2s, then you've got a pretty heavy back tax bill that you're going to be looking at. And I've, unfortunately fielded some calls from potential clients where my best guess is that they were in that situation, probably ended up going under. Yeah. Seeing some of the bills that I've been made privy to.
Well, and that's probably part of the tie back here to the COVID-19 crisis, is that you're already going to be financially stressed. Revenues are going to be down, expenses may be constant to a point, and you're trying to figure out how to make that gap and then get back into the black at some point. But now you're looking at potential problems because of payroll classifications and things like that. This is one of those areas that you really don't want to mess around with. And even though you're not an HR guy, you're a legal guy, you're an attorney, you can add some very good perspective and guidance along those lines. And this may be a good time to pick up the phone and contact Parker to say, hey, look, can you walk me through this? And what are some of the things that I need to know? And talking to your buddy down the street who owns another business isn't necessarily solid advice, right?
Yeah, absolutely. And you hit on financial constraints and building on these gray areas and the reasonable man standard. One of the things I'm looking at as people are beginning to reopen their doors is with this new Families First Coronavirus Response Act, which has various provisions. The long and short is that it essentially creates a new act and amends the pre-existing Family Medical Leave Act. There's going to be a lot of compliance issues with this, but one of the possibly most litigable areas is that if you are an employer under 50 employees, there is a carve out that says if you can't adhere to this, if you can't provide this paid leave, and it's not financially viable for your business, then you don't have to do it. That's the long and the short of it. But the essence of it is that it is a very subjective standard. So just because you may not be able to financially float someone's leave, and you think you have a good argument for doing so, that's ultimately going to be up to the DOL if they ever do a compliance check on you, and you're going to have to, again, produce those policies and procedures. I would write out a memo to me, to yourself, whatever you need to do that says this is why this is not financially viable pursuant to the act. And I'm helping clients of mine tailor those because, we think that most employees want to come back to work. But we're also seeing some that aren't.
Right.
Really, I've seen some with, the CDC guideline that says people over the age of 60 are more prone to contracting and having, fatal issues with COVID-19. And so if you have an employee that's over 60 that doesn't want to come back to work, that opens up a whole nother can of worms.
That's an interesting spin on it. It's, hey, I'm making it available, but now they don't want to come back.
Yeah, so there's a lot of sifting through with, okay, on the one hand, if I make a formal job offer and they refuse it, I have to call the unemployment insurance office and tell them that I have, offered this individual a job and they're choosing to remain on unemployment. The other consideration is that, if you're over 60, the CDC says that you're more prone to the consequences of COVID-19. The other consideration is that if you're over the age of 40 is the cutoff for both state and federal age discrimination. So if you're dealing with older employees, there are a lot of very fine lines that you have to walk, and they are very nuanced conversations that you need to have with those employees, contractors, whatever the case may be, because one thing can lead into another, and there can be individual claims against your company. The DOL can come back and say, okay, well, was this reasonable for you to not provide leave? So that's another situation where it is more worth a 30-minute phone call with me to tell me what's going on for us to get a representation agreement set up and for you to have a good idea of what to do going forward than for you to roll the dice and call me in 6 months when the DOL sends you a notice, and then you're going to be spending several $1,000s trying to get out from under it.
Hey, help me take care of this nasty gram. I think consistency is probably one of the things that people are going to grapple with, because obviously the individual situation may be unique to that individual, but from a company standpoint, how you apply your policies, assuming you have one, is going to be taken into consideration, I would think, correct?
Oh yeah, absolutely. That, if I'm ever a plaintiff suing a company, whether it be representing an individual or a business, you get the policies. If they don't have policies, that's an easy one. You can pick them apart. If they do have policies, then you still have the opportunity to say, okay, how did you implement these policies? Oh, you have an investigation policy, but you have 18 investigations that didn't even closely adhere to these policies. So this policy doesn't really mean anything. So consistency, of course, is key in protection. And, another thing that people may not think about is that having these cohesive, comprehensive policies, having formal contracts with your employees and with third parties, they build legitimacy in your business that actually help your business grow. I have one of my clients, he's, they're a really exciting company, and my value add for them is just getting the foot in the door with formal industries. They have a very niche business. They, a lot of their approach sometimes may go into the spam folder. It may look like a solicitation that most people are going to just click delete on and think, oh, well, this isn't legitimate. Well, they are a legitimate company, but it's hard to build legitimacy in today's world if you're one of these online companies that operates on a national scale.
Right.
So a lot of my value add for them has been, here are your contracts. Here are engagement letters and proposals that I can send to companies. And the response rate from these formal larger companies to me as general counsel has been a lot larger than this company sending out just cold solicitations. Yeah,
it feels more legitimate. It feels more substantive and on the up and up.
Yeah, absolutely. So people want to do business with them because of the formality that they've allowed me to bring to their company.
Yep.
So that, employees are going to be more comfortable if they know exactly what's set out. If you step into an employment situation where you're not sure what your hours are, you're not sure what your obligations are, and then eventually, you're working more hours, you're taking on more and more, and you think, where in the heck did this come from? Well, those are the circumstances that typically give rise to either Fair Labor Standards Act claims and or Kentucky wage and hour claims. And it's so avoidable by getting a couple pages of a contract down and, again, bringing formality to your company and through those means helping your company actually grow.
Well, and that may be one of the silver linings to this whole COVID thing, as we kind of have had time to take a little bit of a time out. And as we start to reopen, making sure the proper foundations are set in place. And what you just said about, hey, having a 2-page or a 3-page, contract and policy right there so that everybody's on the same page, maybe that's one of the positive outgrowths of this whole thing, is that we do understand the importance of it, because there will be litigation out of this. I mean, there will at some point be litigation, and that's one of the most expensive areas of any business, even beyond your operating cost, is a lawsuit or a potential claim that leads to a lawsuit. And Parker, I can't tell you how much I've relied on your advice over the last several years on a variety of topics. And if anybody's out there thinking about, maybe I do need to go ahead and engage. Maybe I haven't done that, or I haven't done that in a while. This would be a good time, to reach out, to the Commonwealth Counsel Group. You guys are located right over there, kind of it's off Lynn Station Road, right? I mean, so you're right there by Plainview and all that, kind of right off of, I guess that's Hurstbourne over there by the expressway, correct?
Yeah, we are. We're right off Hurstbourne. We're over by the APRIS building, the AFLAC building. So we're located. We have free parking. You don't have to go downtown and deal with that. So we're easily accessible. Initial consultations are free, so feel free to reach out. A lot of people ask, well, where's the line with the free consultation? If I'm going to be giving you binding legal advice that you're going to be acting on and associating my name with, well, that attaches my liability policy. So at that point, when we start getting into that, we're going to need a representation agreement. But, for 9 out of 10 clients that call in and they're looking, hey, what's your representation going to look like? I have these questions. Can you even address these? Yes, here's what I can do for you, this, that, and the other. That's usually what an initial consultation looks like. I have those calls all the time. I love meeting new people. I'm always out and about. That's been pretty hard on me with COVID-19. I'm looking forward to coffee shops again instead of Zoom meetings.
Exactly.
But feel free to reach out, ccgattorneys.com. Again, my name is Parker Wornall, and either myself or one of the other attorneys at the firm, we cover a pretty broad spectrum of civil issues. And in the odd circumstances that we can't, I have a good network of other attorneys that I work closely with, some as co-counsel on a variety of cases that I can refer you to. And, ultimately we want to get you taken care of, and we want you to have a good experience with having interacted with us.
Well, Parker, I appreciate the time that you've allowed us to on this podcast. I mean, obviously, we've gone longer than a typical episode, but this is a critical issue for a lot of people right now. Any closing thoughts for a small business owner regarding reopening during this COVID-19 crisis?
Not really anything in specific beyond what we have covered. I think you really generally touched on it a few minutes ago, though. This is a great time to work on your business instead of in your business.
Yeah.
You're not in the weeds. You're not in the office 10 hours a day anymore. This might be a good time to take a step back and say, okay, do I have a little bit of money that I can shell to shore up what we're doing? If you've got draft policies and procedures, sometimes it actually takes me more time to manipulate something you've already got as opposed to just letting me take it and run with it from scratch. But I always I love those clients that are proactive, that come to me with things. They say, here's an idea, here's something I need you to look at. Can you do it?
Right.
To the extent that I can get down to flat rate pricing on predictable things like incorporation, things like that. Jim, I think you'd be surprised with the amount of new companies I've seen pop up in the last 2 months.
Yeah.
Luckily, I haven't had clients that have had to shut doors, but I have had new clients that say, hey, I've got a new business idea. And I think it's great.
There's always going to be a void that will be filled, and people are going to do that. Entrepreneurs are going to find a way. At the end of all this, they're going to find a way, and it sounds like they're already doing that.
Yeah, they are. So I would just say, if you're going to do it safely. Our cost is not cost prohibitive like you might think. It's call me, talk to me. I think you'll find that our firm is a lot more approachable than you may be thinking if you're not a previous purveyor or purchaser of legal services. So it's worth a call.
Absolutely. And friends, once again, in the show notes for this episode, I'll put all of Parker's contact information down there to make it very easy for you. But once again, buddy, I appreciate it. And thanks for your time. Thanks for your advice. And I hope it was helpful to the audience who's maybe out there listening at this time. So with that being said, I hope you have a great day. And that's a wrap for us here on the Grow For It podcast.